Thank you very much, and thank you all indeed very much for coming. And I think I should say, I'm sure the other speakers would, we're very grateful indeed to Guy and his colleagues for setting up such a fantastic occasion and organising it so well. Thank you. Well, there are many different ways of approaching this subject. Guy's already mentioned one, the distinction between the murderer and the attempted murderer, which raises the fascinating question of whether there are distinctions between reasons to try and reasons to succeed. But there are other ways of looking at this particular question. I've only got 10 minutes to talk about them, so I'm going to take a slightly different example and therefore a slightly different focus. But nonetheless, it's a very familiar example, and it's the one well illustrated in the case law, where someone, we'll call them D for defendant, pushes another person unlawfully, we'll call them V for victim, and the victim falls over, hits their head, and dies, which was not something that D intended to do. D only intended the initial assault, the push, which led to the death of the victim. Well, there's a number of questions which we might want to ask and which the law has to ask about that example. Is the defendant responsible? And if responsible, are they to blame? Should they be held criminally responsible? And if so, what for and to what extent? And one might take, because those are different questions, a slightly different line of argument in relation to each. For example, I want to focus in the question of, in relation to that particular example, not on how much the defendant should be punished, as with the question of whether the person is representatively labelled, to use a very helpful and innovative term of Andrew Ashworth's, whether that person is representatively labelled as a killer, if you like, when they push the victim falls over and is killed. Is that an accurate description? I'm not thereby seeking to solve the question or answer the question, should the defendant be more heavily punished in virtue of having killed the victim, if that is what we decide that they did? That might follow, it might even probably follow, but it doesn't necessarily follow, it seems to me. Well, let me turn to the first question then, having secured our focus on representative labelling, or something like that. Has the defendant, in causing the death of the victim, done something that he or she should not have done? Now that's a normative question. It's a question about normative rules. And I've no hesitation in saying that the defendant has done at least two things that he shouldn't have done, probably many more, but two things. He or she has assaulted the victim and killed the victim. That doesn't get us all the way to saying, of course, that there should be criminal liability, but it's a start. So there are two norms transgressed, assault and killing. Now, why is that? It might even seem trivial to some of you, although I think that the more one thinks about these things philosophically, the more there seems to be no such thing as a trivial question in this area. But it is an important question to address because if we think, for example, about Michael Moore's famous argument that moral luck is already accounted for in the criminal law through the rules of causation, that they determine the limits, as it were, of the luck to which one is subject. It seems to me that in making this argument, which I think is, broadly speaking, quite a good argument, nonetheless, I think it's important to recognise that he has the normative part of the criminal law in mind when making this argument about moral luck. In other words, if the death of the victim is so aberrant a consequence, I push them and then they're struck by lightning on the spot on which they fall or something, if it's so aberrant as to not even to be attributed to me as a matter of causation, well then it's not something I ought not to have done. I apologise for the double negative. But it seems to me to affect the normative question of whether I have or have not done something I ought not to have done. And it seems to me one can say, well, no, causation breaks that link, takes me outside the scope of the norm prohibiting killing. So that's fine as far as it goes, but it doesn't seem to me to address the question, the ascriptive question, if I may draw a helpful distinction set out with admirable clarity by Professor Raz between normative and ascriptive rules. The problem with Moore's argument is that it's too narrowly focused, I think. He doesn't consider the ascriptive question of whether the defendant is to blame for killing the victim in my example, even if we accept that he has transgressed the norm, because the killing of the victim is not too remote, causally speaking, for that issue to be in play. Can we still blame the defendant and hold the defendant criminally responsible? Well, of course, there are a number of answers here, aren't there? One is to say that the defendant's not to blame unless he or she intended or foresaw the death itself. Well, I wouldn't accept that argument, because it seems to me that blame, if we're concerned with blame includes negligence, liability for negligence, and one can kill negligently, it seems to me, and D may have been negligent in bringing about the victim's death. Some jurisdictions treat the matter in that way. I don't think he definitely was, but he might be. And of course, some, we don't want to get into this argument now, but some have argued that it's perfectly appropriate to hold people liable for consequences on the basis of negligence in bringing about those consequences. There is nonetheless a strong argument for saying that blame for unintended consequences should be based on, at the very least, foresight or negligence as to bringing about those very consequences. So in my example, we need to ask the question, did the defendant foresee the death as a possibility, or was he or she grossly negligent in bringing that very outcome about? And of course, sometimes the law goes wrong in attributing consequences far too readily to offenders. A very good example is causing death by dangerous driving, which most people, I think, are unfamiliar with the actual Road Traffic Act. And I'm not encouraging you to become familiar with the Road Traffic Act, but most people unfamiliar with that act would assume that dangerous driving involves posing a danger of death. Not so. A danger of property damage of a serious kind will be sufficient if death is caused to make you guilty of causing death by dangerous driving. Now that really casts the net very wide by making negligence as to one thing sufficient to make you liable for bringing about another rather more serious thing. So the law plays, we may all admit, fast and loose with the relationship between blame and consequence.